So, with that said, I want to now turn it over to our managing attorney over in our Tampa Bay office. This is who I affectionately call our walking encyclopedia. She is amazing. You're in for a treat today. This is Kirsten Hensa for HOA Financial Literacy and Transparency. Take it away, my friend.
Thanks, Jeff. Well, good morning, everyone. Like Jeff mentioned, I'm Kirsten Hensa. I am one of the attorneys with the law firm of K. Bender Renbaum. For those of you who are not familiar with the firm is an exclusive community association law firm. So that means that we focus our practice area on representing community associations in the state of Florida. So that includes your condominium associations governed under Chapter 718 of the Florida statute, your HOAs governed under Chapter 720 of the Florida statute, and cooperatives governed under Chapter 719 of the Florida statute. We do have multiple locations throughout the state of Florida, with a main office being in South Florida in Pompano Beach, as well as we have offices in Palm Beach Gardens, the Orlando area, and again, I'm on the West Coast, and our office is located in Tampa. Okay, so without further ado, let me go ahead and share my slides.
We see it. Perfect.
See them? Perfect. All right. All right, so what we're going to talk about today is financial literacy for HOAs. Those are associations that are governed under Chapter 720 of the Florida statute. So we'll start with board compensation, kickbacks, and then discuss briefly conflict of interest. So with regard to compensation, what we're talking about here is directors and officers being compensated for their services as a director or officer. And what the statute says, section 720.303, subsection 12 of the Florida statute, it states that a director, officer, or committee member may not directly receive any salary or compensation from the association for the performance of duties as a director, officer, or committee member, and may not in any way benefit financially from services to the association except for the following. Okay, so the general rule is you're not allowed to get compensated for providing services as a director, officer, or committee member unless any of the following exceptions apply. And they include participation by such person in a financial benefit accruing to all or a significant number of members as a result of actions lawfully taken by the board. So that could include, for example, if the association enters into a bulk service agreement or a bulk marketing agreement whereby the association is receiving what is referred to as a door fee or compensation of some sort, because all the owners are benefiting from that, that form of financial benefit is acceptable. As well as reimbursement for out-of-pocket expenses incurred on behalf of the association, subject, of course, to any applicable approval procedures. Recovery of insurance proceeds derived from a policy of insurance maintained by the association. And then any fee or compensation that's either authorized in the governing documents or is authorized by a vote of the majority of the voting interests voting in person or by proxy at a meeting. So that's not a majority of all the voting interests. That's just a majority of quorum. Okay, so it's a much lower percentage. Kickbacks. So the statute was amended several years ago to now expressly provide that an officer, director, or manager cannot solicit, offer to accept, or accept a kickback. And the term kickback has been defined in the statute, and it means anything or service of value for which consideration has not been provided for an officer, director's, or manager's benefit, or for the benefit of any immediate family member from any person providing or proposing to provide goods or services to the association. The statute also provides that an officer, director, or manager who knowingly violates this prohibition commits a third-degree felony and is subject to monetary damages. And an officer, director violating this prohibition must also be immediately removed from office by the board, which creates a vacancy that can be filled by the remaining directors. That said, the statute does say that an officer, director, or manager may, however, accept food to be consumed at a business meeting with a value of less than $25 per individual, or service or goods received in connection with trade fairs or education programs. So many of you might be familiar with certain community association trade shows that take place throughout the state, at which vendors attend, and they can provide certain goodies or knickknacks, and board members can attend these trade shows, meet some of the vendors that provide services to community associations. And any of those, goodies that you get from these trade shows, they're not considered a kickback. Similarly, if you attend, a seminar or let's say like a lunch and learn that is taught by, some division approved provider, you can take the credits and also, have your lunch or your breakfast, and that would not be considered a kickback. Okay, some grounds for immediate removal. So, director or officer charged by information or indictment with any of the following crimes must be removed from office. And those crimes include forgery of a ballot envelope or voting certificate used in an election, theft or embezzlement involving association funds, tampering with physical evidence, destruction of or refusal to timely allow inspection or copying of an official record in furtherance of a crime, obstruction of justice, and then any other criminal violation under the HOA Act. The board must fill the vacancy if such vacancy has been created until the end of the period of the suspension or the end of the director's term of office, whichever occurs first. However, if the charges are resolved without the finding of guilt or without acceptance of a plea of guilty, then the director or officer must be reinstated. Now, if criminal charges are pending, this individual cannot be appointed or elected to any position as an officer director of any association and may not have access to any official records of the association. Now, another ground for removal of a director, once you have been elected or appointed to the board, a director who becomes more than 90 days delinquent in the payment of any fee, fine, or other monetary obligation to the association is deemed to have abandoned their seat, which creates a vacancy. So note that it's not just a delinquency on assessments, whether it's regular or special assessments. It includes, any attorney's fees, any costs that may have been incurred, possibly in collection efforts or any other legal action. It would include interest or any late fees that have been imposed against the delinquent account. And then certainly fines, right? So if the director happened to have been to have violated a covenant or a rule, at some point, even maybe before getting on the board, and the fine has not been paid, then that would be another basis for removal. And note that the way the statute is written, there is no affirmative action that the board needs to take in order to create this vacancy. The director is automatically deemed to have abandoned the seat, which creates a vacancy. So the board doesn't have to vote on anything. All right, let's quickly go over conflicts of interest. So initially, the statute provides that the directors and officers have to disclose to the association any activity that may be reasonably construed to be a conflict of interest at least 14 days before the board will either vote on the issue or approve any contract that would be subject to the conflict of interest. Well, what is a conflict of interest? The statute says that there is a rebuttable presumption of a conflict of interest if any of these two things exist. Either the director, officer, or relative of the director or officer enters into a contract for goods or services with the association, or these individuals have an interest in an entity that is looking to enter into a contract for goods or services with the association. So a typical example of this would be if a director owns a landscaping company, right? And the director wants to offer services to the association, right? So if that director has an interest or owns the company, then there is a rebuttable presumption of a conflict of interest. Now, note that the statute does not define the term relative for purposes of this section. Now, if a conflict of interest exists, the statute doesn't say that you can't enter into, that the association can enter into the contract with this interested director, but it does provide a procedure that the association has to follow in order to properly approve that transaction or contract with the interested director. And the steps include that the contract with the director must be fully disclosed to the board. The disclosure has to be entered in the minutes of the board meeting at which the board is going to consider the contract. And then the contract would have to be approved by 2/3 of the directors present. Okay. The contract or the proposed transaction with the director has to be reasonable and fair. And then the final step, and this is what most board members miss, is that at the next regular or special membership meeting, you'll have to disclose the existence of this contract or the transaction to the membership. Okay. Now, if at that membership meeting, any member, upon a member's motion, there's a motion made by any of the members to cancel or terminate that contract, if a majority of the owners approve the termination, then the contract may be canceled. Okay. Now, if the contract is canceled in this fashion, then the association will not be liable for any liquidated damages or any termination fees or penalties for terminating the contract early. So the association would only be responsible for the cost of goods or services through the date of termination. All right, so let's switch gears and move on to official records. So as you may be aware, Chapter 720 of the Florida statute has a laundry list of records that the association has to maintain as part of their official records. I did not include here the entire laundry list of records. You can, go on Google and Google Chapter 720 and do a search word to get the list. What I did include on the slide are just the records that relate to, financial accounting records. So among all the other records that have to be maintained by the association, you also have to maintain copies of all contracts to which the association is a party. You have to maintain bids received by the association for work to be performed. And we'll talk about the retention period, but note that for bids, they have to be capped at least 1 year. And then in terms of financial and accounting records, the following minimum records have to be maintained by the association, including accurate, itemized, and detailed records of all receipts and expenditures, a current account and periodic statement of account for each member, so your account ledger for each member of the association, all tax returns, financial statements, as well as financial reports. And we'll talk about financial reports later on in the webinar. And then any other records that identify, measure, record, or communicate financial information. And then the last bullet is the catch-all provision that's in the statute that provides that all other written records of the association that are not specifically identified, which are related to the operation of the association. So, for example, bank statements, while the statute doesn't specifically say you have to maintain bank statements, obviously those are financial records of the association, and therefore you should be maintaining them as part of the official records. Okay. In terms of retention, the statute provides that the official records have to be maintained for at least 7 years, unless, of course, your governing documents require a longer period. And then bids received by the association have to be kept for a year. Now, effective July 1st of 2024, the statute requires HOA associations to adopt written rules governing the method or policy by which the official records of the association are to be retained and the time period such records must be retained. And this information has to be made available to owners through the association's website. Now, there are certain records that are not accessible to owners, which means that if any owner requests to see any of these records, they are not the type of records that are subject to inspection. And they include, for example, records that are protected by attorney-client privilege. So, for instance, if you have legal counsel and you've requested your attorney to provide legal opinion to the association, that opinion is protected by attorney-client privilege. Now, that said, only the board, only the client can waive privilege. So, if the board wants to waive privilege and provide owners with a copy of a legal opinion, that's obviously a business decision of the board. Now, information obtained in connection with the approval of a sale, lease, or other transfer of a parcel. So this might come into play if your association has the authority to approve or disapprove sales, leases, and other transfers, in which case, typically as part of the approval or application process, the applicant, the prospective buyer or tenant, have to fill out an application, and then typically they have to go through a background check, criminal, and then a credit check. And so all of that information, all of that documentation is protected and is not accessible to owners. Information obtained in a gated community in connection with guests' visits to owners or residents. And then things like social security numbers, driver license numbers, credit card numbers, email addresses, and any other address that has that is on file of the association, which has not been provided to the association for purposes of fulfilling notice requirements. Now, note that if an email address has been provided to the association and the owner has consented to receiving notices by email, those email addresses do become accessible to the rest of the owners. Okay, there are certain official records crimes. In 2024, the statute was modified to criminalize some conduct regarding records inspections. And what the statute currently provides is that any director or manager who knowingly, willfully, or repeatedly fails to provide access to the official records with the intent of causing harm to the association or its members commits a second-degree misdemeanor. Now, the term repeatedly is defined as 2 or more violations in a 12-month period. Also, any person who knowingly and intentionally defaces or destroys accounting records, or who knowingly or intentionally fails to create or maintain accounting records that are required to be created with the intent of causing harm, commits a first-degree misdemeanor. And then any person who willfully or knowingly refuses to release or otherwise produce association records with intent to avoid or escape detection, arrest, trial, or punishment for the commission of a crime, or to assist another person with such avoidance or escape, commits a third-degree felony. Now, in terms of website requirements, just a reminder, hopefully by this point, board members have complied, but just as a reminder, by January 1st of 2025, associations having 100 parcels or more must create a website or an application for posting association documents. Now, I'm not going to go through the laundry list of everything that needs to be posted on the website, but here's a few of the items just so that you have the slides. So certainly all of your governing documents, your rules, and then a list of all executory contracts or documents to which the association is a party. Your annual budget, and any proposed budget to be considered at the annual meeting. Financial report and any monthly income or expense statement to be considered at a meeting. You have your insurance policies, certifications required of each director, all contracts between the association and any director, officer, firm, or other association that's not affiliated with your association, or any other entity in which the association director is also a director or officer. Any contract or document regarding a conflict of interest. And then notices of board and membership meetings, as well as records or documents that are associated with the meeting. So if you are, for example, considering approving a contract at your next board meeting, not only do you need to post notice of that meeting on your website, but also the copy of the contract. Okay. All right, budgets and reserves. So as many of you may be aware, the association has to prepare an annual budget every year that reflects the estimated revenues and expenses for the upcoming fiscal year. Now, the budget has to set out separately all fees or charges paid for by the association for recreational amenities, whether they're owned by the association or not. So essentially, your budget is going to have two components. You're going to have a section of the budget that includes all your operating expenses, and then you may or may not have a reserve section of the budget. And when I use the word reserves, I'm going to refer that to those reserves as statutory reserves. Okay, and we'll talk about that in a minute. But in terms of practical tip, obviously, use last year's actual expenses to plan for your next year's budget. And then also note, monies that are in your operating section of the budget, they are not restricted to any particular purpose, right? And so therefore the board can use monies that are allocated to one operating line item for other purposes, bona fide purposes that are authorized under your governing documents, right? So for example, if you've allocated funds for your insurance premium and you got an awesome notice from your insurance agent saying your premium went down this year or next year, and you paid your premium, and however you are short on the repair line item budget, right? You've had too many unanticipated repairs, let's say to your clubhouse. You can use the surplus from that insurance line item to pay for the repairs. Okay, so any bona fide for any bona fide association purpose. Now, the operating expenses have to be listed by account and classification and should project the total proposed annual expenditure in each classification. So I've included here some examples of operating line items that you might see in a budget. They may include your administrative management fees, certainly maintenance and repairs of your common areas, rent for any recreation facilities. If you have a rec lease, taxes, insurance, and you should also have a line item for professional fees, right? Which, include your accountant or legal counsel. And of course, you might have, additional line items in your operating budget. Now, in addition to your operating budget, the budget may also include reserve accounts for capital expenditures and deferred maintenance. Now, I've included here definitions for capital expenditures, deferred maintenance, which you can read at your leisure. But typically, they would include things like pavement resurfacing. If you own the streets in your community, they have to be resurfaced after a certain period of time. So that's a capital improvement project. Repairs, improvements to common areas, association property, or common facilities, sidewalk improvements, and you may have, additional capital improvement projects. But the important thing to note is that when boards in HOAs, which is very different from condominiums, but when boards use the word reserves on their budget, typically they mean a discretionary or an emergency fund, right? In case a hurricane comes and we have to clean up, let's reserve or put aside some money for the cleanup. Or, the clubhouse roof requires replacement in the next 5 years. Let's put some money in that, reserve fund for the roof replacement. Those reserve funds may not necessarily be statutory reserve funds. The statute, Chapter 720 of the Florida statute, says that the only way that statutory reserves can be created is either if the developer created them or they were created by the membership, by a vote of a majority of the total voting interest. So the only way you would really know this is you'd obviously have to go back to your official records and see if you have any documentation confirming whether or not the membership voted to create statutory reserves. If you don't have that documentation, then it's very possible that you don't have statutory reserves. If statutory reserves were created, then what that means is that those reserve accounts must then be funded, maintained, and can only be waived in the manner provided in the statute. If the reserve accounts were not created in accordance with the statute, so you don't have a membership vote confirming that creation of reserves, or there's no indication that the developer created the statutory reserves, then essentially they're not statutory reserves. They're nothing more than operating funds, which means you have more flexibility to use those operating funds for bona fide association purposes. If they're statutory reserves, however, you are limited to how you fund, use, and waive those funds. So first, presuming you have statutory reserves, the amount to be reserved will be based upon an estimated remaining useful life and estimated replacement cost of the deferred maintenance expense. So typically, you'll have to get a reserve study, which is conducted by a reserve specialist or an engineer. They will come to your property. They will evaluate your common areas, your clubhouse, your roads, whatever else you're required to maintain or you own. And they will come up with a schedule, right, of the useful life of the asset, what the remaining useful life of the asset, what the estimated replacement cost or repair will be, at the end of the useful life. And then you'll have a schedule essentially of how much money it's going to cost you to undertake these repairs at the end of the useful life of the asset, and how much money you have to set aside or fund every month. Okay, that's what is referred to as reserve schedule. Now, for statutory reserves, you're going to have to fully fund your reserves in accordance with the schedule every month. Okay. Reserve funds and then any interest accruing on those reserve funds must remain in the reserve account and then can only be used for authorized reserve expenditures. So if you have a reserve account for your clubhouse roof replacement, then those funds allocated for that roof replacement can only be used for that particular purpose. If you have reserve funds allocated for your pool resurfacing or your pavement resurfacing, they can only be used for those particular purposes, unless, of course, their use for alternate purposes is approved by a majority vote of the members at a meeting at which a quorum is present. So there is an option to use dedicated statutory reserves for alternate purposes, but only if you get the membership approval required in advance. Now, statutory reserves can be kept in one or two ways. There's the traditional, individual account reserve accounts, or you can create pooled reserve accounts. A pool reserve account is one where you're essentially holding money for at least two or more statutory reserves. So you can create a pool, for example, your pavement resurfacing and building painting or clubhouse painting. The benefit of the flexibility that a pooled reserve account offers is that if, for instance, you have to resurface your pavement, and you're short on what you have been reserving for that particular purpose, you can use money that you've allocated to painting in that pool to pay for pavement resurfacing without getting a vote of the membership. Because remember, statutory reserves can only be used for their particular purpose unless you obtain membership approval. Well, with a pooled reserve account, you can use any money that's within the pool for any item, any reserve item within the pool without getting membership approval. At one point or another, you're going to have to catch up and refund those funds, and that's something you'll have to discuss with your accountant. But that's the benefit. Now, to create a pooled reserve account, if you don't currently have one, that would also require a vote of the membership, right? Because you're essentially taking dedicated statutory reserve funds and you're now using them potentially for alternate purposes. So you would need membership approval to create pooled account, and you'll need to get a vote of the majority of the members present at a meeting. Now, another thing with statutory reserves is that you have to fund them every year based on that reserve schedule that I mentioned earlier on. You do have the option of giving owners the option to either waive or partially fund those statutory reserves in any given year. Now, it is completely discretionary and within the business, a business decision of the board, whether or not you even want to give owners that option. So if you, the board, feel that you need to fully fund statutory reserves on any particular year, then that's a business decision. If you are going to give owners the option to either waive reserves for a particular year or just partially fund, then you will need to get membership approval. And the vote that you'll need to get is the majority of the voting interest present at a membership meeting. So it's not a majority of all, it's just a majority of those who are present at a membership meeting at which a quorum is present. Now, if you do get a vote of the owners to either waive or partially fund reserves, that vote is only applicable for the budget year the vote was taken. So if you get this vote for for the 2026 budget year, in 2027, you'll either have to fully fund reserves or you'll have to again present a vote to either waive or partially fund. So every year the owners will have to vote on this. If you currently have statutory reserves and you want to terminate that, there is that option. However, also it has to be approved by the membership, and the vote you'll need to get is a majority of the total voting interest. So a majority of the entire membership. All right, let's switch gears to notice and adoption of the budget. So you'll have to review your governing documents for any specific budget meeting notice requirements, okay? If your documents are otherwise silent, then notice of the meeting at which you're going to adopt your budget simply has to be noticed at least 48 hours prior to the meeting. Unless your governing documents require the budget to be provided to the owners before the meeting, you're not required to do so. You may want to consider doing so, however. After the budget is adopted, the association must provide each member with a copy of the budget or written notice that a copy is available and will be provided at no cost. If requested by the owner, a copy of the budget must be provided to the member within the time frame set forth for inspection of records, which is within 10 business days after receipt of the written request. And then again, just a reminder that January 1st of 2025, you are required to comply with the website requirement if you have at least 100 parcels in your community. Okay. Let's switch gears to assessments and foreclosures. Let's start quickly with special assessments. So notice of your board meeting at which you're going to consider a special assessment has to be mail delivered or electronically transmitted, so meaning via email. To members and posted on community property at least 14 days before the meeting. Now, the statute says that the notice of the special assessment must include a statement that the special assessment will be considered and the nature of the assessment, and should identify the estimated cost of the assessment. Once you, the board, adopt the special assessment, you should be sending written notice to your owners, letting them know that the special assessment has been adopted, what each owner's proportionate share of the assessment will be, excuse me, and then provide them with a reasonable opportunity within which to pay the assessment. Now, the board is the one that will set the terms of the special assessment. So if the special assessment, if you want it to be paid within 3 months, 6 months, however, whatever you decide, that ultimately is a business decision of the board. And then a special assessment that is not timely paid by an owner can be collected through the lien foreclosure process, just like any other assessment. Now, effective July 1st of 2024, this new requirement went into effect. So just so you're aware, a parcel owner may make a written request to the board for a detailed accounting of any amounts that he or she owes to the association related to the parcel, and the board must provide such information within 15 business days after receipt of the written request. Now, after the parcel owner makes this request, they may not request another detailed accounting for at least 90 calendar days. Now, the consequence for failing to provide this accounting to the owner within the 15 business days time frame is that it will constitute as a complete waiver of any outstanding fines of the person who requested the accounting, which are more than 30 days past due and for which the association has not given a prior written notice of the imposition of the fine. Now, collection of assessments. The statute provides that assessments that are not paid when due, whether it's regular or special assessments, they will bear interest at the rate that's provided in your declaration or the bylaws. And if no rate is provided, then you can collect interest at 18%, which is the current rate in the statute. Late fees, the statute provides that an administrative late fee can also be imposed, provided you have the authority to do so in your declaration or bylaws. And the late fee cannot exceed the greater of either $25 or 5% of the amount of each installment. And you cannot charge interest on interest or interest on the late fees. And then, of course, the association is entitled to collect attorney's fees and costs incurred in any collection efforts. The statute also identifies how payments have to be applied. So if an owner has made a payment towards their delinquent assessment, then that payment has to first be applied to any interest accrued, then to any late fees, then to any costs or reasonable attorney's fees, and then to the delinquent assessment. Okay, so it's not unusual when a delinquent owner has cut a check towards their delinquent assessments, and they soon find out that that payment did not completely pay the entire delinquent amount. And that's because this is how payments are applied. And, your assessment is the last thing that the payment gets applied towards. So, okay. Notice of late assessment or NOLA. So this has been in the statute for several years now. And what the statute provides is that the association can't recover attorney's fees related to a delinquent account incurred in collection efforts unless the association first provides the owner with this statutory notice of late assessment or NOLA, basically giving the owner 30 days to pay the delinquent assessments. Okay. Now the statute provides a form that can be used. And it also provides that the NOLA has to be sent by first class U.S. mail. So it doesn't have to be sent by certified mail. And there is a rebuttable presumption that the association mailed the notice if the board member, officer, or agent of the association or property manager signs an affidavit attesting to the mailing. Okay, so you need to have a copy of the NOLA as well as a copy of this affidavit of mailing in order to pursue collections foreclosures. Any firm that you end up hiring to pursue collections will require this documentation. Certainly we will. Now, the statute provides also that before you can record a claim of lien, the association has to provide the delinquent owner with what is referred to as a notice of intent to lien, giving the owner 45 days an opportunity to pay their delinquent amount. So not only do you have to provide the 30-day opportunity to pay in the NOLA, but then another 45-day opportunity with the notice of intent to lien. And then before you can foreclose, you have to provide the delinquent owner with another 45-day opportunity to pay the delinquent amount before you can file a foreclosure action. Now, first mortgagees, the liability of a first mortgagee or their successor who acquires title to a parcel by foreclosure or deed in lieu of foreclosure is going to be the lesser of these two amounts. It's either the the unpaid assessments that accrued on the account for the preceding 12 months prior to taking title, or 1% of the mortgage debt. So if a mortgagee ultimately takes title to a parcel in the community, then under the statute, their obligation to pay assessments to the association is going to be limited to the lesser of these two amounts. Just note that the limitation on first mortgagee liability will apply only if the first mortgagee initially joined the association as a defendant in the first mortgagee's foreclosure action. More for your legal counsel to know, but now you're also aware. Now, a third-party bidder at a foreclosure has joint and several liability of any past due assessment. So if the third-party bidder is not, if we're not talking about first mortgagees, we're talking about any other third-party bidder, that they would be entitled for any, they would be responsible for any past due amounts that accrued prior to them taking title. Be aware, however, that when the association, if the association ended up foreclosing on the property and then had title at some point, and then the lender foreclosed its interest, the third-party bidder would not be liable for any assessments that accrued during the time that the association owned the property. Let's quickly go through financial reports. We're almost at the end. So financial report concerns the year-end financial report, right? So like a financial audit. So each year the board has to prepare or complete a financial report of the financial activities for the preceding year within 90 days after the end of the fiscal year, or annually on the date provided in the bylaws. So if the bylaws don't designate a date, then you have to have this annual financial report prepared by the end of the fiscal year. Now, your fiscal year could be a calendar year, or could be, some other date. Typically, it's set forth in your bylaws. Now, the statute also says that within 21 days after the report is completed, but no later than 120 days after the end of the fiscal year, the board has to either provide a copy of the financial report to the owners, or has to give them written notice, letting them know that the financial report has been completed and will be provided to the owner free of charge. Now, the level of financial reporting is going to depend on the annual revenue of the association. So unless your bylaws provide for specific financial report, such as an audit, unless your bylaws require an audit, your level of financial reporting will depend on the threshold set forth here in the statute. So, for example, if your annual revenue falls between $300,000, but it's less than $500,000, then you are statutorily only required to prepare reviewed financial statements. If your annual revenue is $500,000 or more, then you are required to do a financial audit. Now, as of July 1st of 2024, regardless of your total annual revenue, an association with at least 1,000 parcels is required to prepare an audited financial report. There is a statutory procedure to increase the level of financial reporting, but essentially the members can petition the board to increase the level of financial reporting, and the membership would need to approve that by a vote of the majority of the total voting interest. Okay. There is also an option to lower the level of financial reporting, but again, you'll need the approval of the membership. Again, majority of the voting interest present at a meeting is who would need to vote to lower the level of financial reporting. And then here, I'm not going to read them, but I've included here certain disclosures that your financial report needs to include. So, excuse me, if the budget does not provide for statutory reserves, or the governing documents do not obligate the developer to create reserves, or if the statutory reserves are not fully funded, then the top disclosure is what you would be including in your financial report. If the budget does not provide for statutory reserves but includes discretionary reserves, then the lower disclaimer is what you would be including. All right, let's quickly review contracts and bids. So under the statute, Chapter 720, the contracts that cannot be fully performed within 1 year for the purchase or lease of materials or equipment, and service type contracts have to be in writing. Okay. And then we've included just some tips of some things that you might want to be on the lookout whenever you are considering contract. But as a practical matter, strongly recommend that you have your legal counsel review any contract that you're looking to enter in to just make sure the interests of the association are protected. Bidding, the statute provides that if the aggregate cost of the contract is more than 10% of the total annual budget, and that includes statutory reserves, then the association must obtain competitive bids for material, equipment, or services. Now, the statute doesn't say how many bids you have to obtain. Typically, 2 to 3 bids is pretty standard, for associations. The association is not required to accept the lowest bid, and you're also not required to obtain competitive bids for products or services in emergency circumstances. You're also not required to obtain bids for products or services when the business entity with which the association desires to contract is the only source within the county. And then contracts executed before October 1st of 2004 and any renewals there are not subject to competitive bidding requirements. Also note that the following contracts are exempt from your bidding requirements. So contracts with your attorneys, accountant, architect, community association manager, engineer, landscape architect. These contracts have to be in writing, but they're not subject to the bidding requirement. All right, estoppel certificates. This might be the last main section. So estoppel certificates will come into play when you have an owner in the community that is looking to sell their property. Typically, there's a title company involved in the transaction, and the title company will contact the association, typically the property manager, and request certain information on the parcel, such as, is the parcel delinquent or current on all their assessments, right? And so that inquiry or that request is done through what is referred to an estoppel certificate. So the statute addresses how you have to respond to these requests and fees that you can charge. So within 10 business days of receiving a written or electronic request for an estoppel certificate from either the owner, a mortgagee, or their designees, the association has to issue an estoppel certificate. The association has to designate on its website the person or entity with a street or email address for receiving, who will be receiving and responding to estoppel requests. And they may be completed by either a board member, authorized agent, authorized representative, including, your management company. Estoppel certificates must be provided by either hand delivery, regular mail, or email, and they must be signed off by an officer or an authorized agent of the association. Now, the good thing is that the statute actually includes a form of a statutory form for an estoppel certificate, which I've included here in the next few slides. So a portion of the certificate is going to include general information about the association and the owner. And then there's going to be a section about assessment, right? This is where you're going to include, what is the amount of your regular annual assessments levied against the property, the date that the assessment is paid through, the date of the next installment of your assessment. You'll include an itemized list of all assessments, special assessments, and other monies owed on the date of issuance to the association by the owner of the specific property. So here's where you want to identify all monetary obligations that are owed by the owner to the association. And then there's a section in the estoppel for other information. For example, is there a capital contribution fee that has to be paid at closing, or is there a transfer and application fee? So typically, if the association is authorized to approve and disapprove buyers, right, there's typically an application fee that goes with that. Here's where you would identify that. Importantly, I want to point to number 2. Whether there's any open violation of a rule or regulation noticed previously to the owner of the property. So this is where you also want to identify what outstanding or open violations exist on the property. For example, did the owner perform some unauthorized alteration? Did they paint their house pink without board approval, right? You want to make sure to note the violation on the estoppel, because if you don't, once that sale closes and you try to enforce that open violation against the new owner could raise as a defense, potential waiver defense, in that, you had an opportunity to let the buyer know of the violation, you didn't do so, and now you've waived the ability to enforce the violation against the new buyer. So make sure that you identify any open or outstanding violations. The association can charge a reasonable fee for responding to these estoppel requests. So we've included here the current rates. So if the owner is not delinquent, then a reasonable fee not exceeding $290 may be charged for preparing the estoppel. If the owner happens to be delinquent to the association, you can charge an additional $179 for responding to the estoppel request. If the responses to the estoppel request are being requested on an expedited basis and you can respond within 3 business days, you can charge an additional $119. Okay. If the association fails to deliver the estoppel within the 10 business days of receiving the request, then you cannot charge the fee. If the certificate is requested in conjunction with the sale or mortgage of a property, but the closing does not occur, and no later than 30 days after the closing date, the preparer receives a written request accompanied by reasonable documentation that the sale did not occur, okay, then the fee must be refunded to the payer within 30 days of receiving the request. Now, estoppel certificates, responses, if they are delivered by hand or by email, they are effective for 30 days. Estoppel certificates that are delivered by mail, they're good for 35 days. Now, if you have to amend an estoppel certificate, you cannot charge an additional fee for amending. An amended estoppel certificate must be delivered on the date of issuance, and a new 30 or 35-day effective period then will begin. And then lastly, the association waives the right to collect any monies owed in excess of the amount specified on the estoppel certificate from any person who in good faith relies upon the estoppel certificate. So again, if you fail to identify on the estoppel certificate all amounts owed to the association, then that waiver defense comes in. Okay, and you might be precluded from later collecting those amounts owed from the buyer. Okay, I guess this was my last slide.
You guessed correctly. Well done.
Stop sharing here.
I didn't even see you take a sip of water. You did it all
I
without
know.
without anything. Now's your opportunity, Kirsten. So we're going to answer a few of the Q&As in a moment. Kirsten will look through those in just a second. But before we do that, if you haven't already done so, please press the chat button so it appears on your screen. We've already placed the online post-webinar form link in there a couple of times. We'll do it again. So please make it so you can see the chat area, not to be confused with the Q&A area. Once you do that, it's going to take you to a screen to, let me share this real quick. Once you do that, when you click or tap on the link in the chat, it takes you to the post-webinar form to fill out. It's not as daunting as it looks. It goes quickly. Anywhere you see an asterisk, please make sure there's something in there or it's selected. Those are required fields. Another common mistake that we see for an unsuccessful submission, make sure your email addresses match. If it does not, it will yell at you and tell you under here that your email address does not match. Another thing to be cognizant of is when you click "I'm not a robot," wait until the little circle stops spinning and becomes a check mark. If you hit submit while the circle is still spinning, it will not go through. So after you submit it, you get to this confirmation screen. This is where you have Kirsten's contact information, the firm website link, and what many of you inevitably will ask about. You click here, this first bullet point, to download and save today's slides. When you do that, you click on that, slides open up. You can then right-click, save, or print. That should work on any browser, any operating system, any device that you may be using. Remember, the information you put onto your valuation, the email address, that's what we use to send you your certificates via email. So it's important that you follow the directions on there. For example, it tells you to enter your name not using all capital letters. If you do that, your certificate will look funny because of the script font. So just be sure you read the instructions on the form before you just fill it out quickly without paying attention to what it says. With that said, I will now turn it back over to Kirsten to address a few of the Q&A. And if you're going to type in a question, make sure it's on topic. It's got to be related to what we talked about today. Do not write a novel. We're going to skip those. We don't have time to read chapters of books today. So please keep it on topic, and and if we don't get to your question, there's 200 of you here. Please don't be offended. It doesn't mean it's a bad question. It just means Kirsten has a full day of work today. She'll do a few of them, and then we're going to let her get out of here. And remember, this part, the Q&A, it's bonus, not required. After you've done your online form submission, you can go if you choose to. My friend, back to you.
All right, let's see. If any of this information is in a document that is accessible to owners, must be redacted before release. I'm not sure what records this gentleman is referring to, but typically any document that is accessible to the owners typically cannot be redacted. Okay, now if we're talking about things like, bank statements and there's account information for security purposes, I would say you could redact the account numbers, but generally most information that's accessible to owners should not be redacted. Are pooled reserves the way to go? Correct. Well, again, pooled reserves would come into play if you have statutory reserves. It certainly offers flexibility. So something that you might want to consider discussing with your legal counsel and attorney. Accountant. Let's see here. Our documents require member approval for any special assessment. Does the statute allow the board to levy the assessment anyways? Well, I mean, that's a bit of a document specific question. So, um, yes, I've come across where governing documents might require boards to adopt a special assessment, but I guess you have to analyze what the special assessment is for, right? If we're talking about, capital improvement, such as, turning your tennis courts to pickleball courts, right? And you want to adopt a special assessment for that purpose. That doesn't sound to me like a necessary maintenance issue. And so if your documents require membership approval for that, for those types of projects, then you likely will need that approval. If we're talking about a necessary maintenance project, right? You need to replace the roof and you need to of a clubhouse and you need to adopt a special assessment. There is case law that supports the ability of the association to adopt the special assessment in those limited circumstances without getting membership approval. So I would just, have a further discussion on this with your legal counsel. How much do they have to pay to avoid a lien? I mean, typically, if we're talking about a delinquent owner who hasn't paid their assessments, obviously they'll have to pay the full amount of the assessments. Plus, it depends if your governing documents allow to collect interest and then late fees. The owner would be responsible for those as well. If you've incurred attorney's fees in any collection efforts, you want to talk to your collections attorney on this a little bit in further detail.
Hey,
Let's see
George,
here.
before cursing it, George, this video and our past videos will be on the association website, the firm website, in a few days. I'm a bit behind on that due to our pending deadline for HOA board member education, but I anticipate being caught up with everything by the end of the weekend. Kirsten, back to you.
Please clarify late fees. No interest can be charged ever on late fees, and they can only be charged once per occurrence. So, late fees, by that we mean administrative late fees, per the statute. I'm not referring to late fees as in late assessments. Okay. So there's the late assessment. If your governing documents allow the association to charge an administrative late fee, right? Either 25% of the installment or $5. 5% of the installment or $25, then you can charge that late fee per delinquent installment. So if assessments are paid monthly, then every month that the assessment is late, you can tack on that $25. Okay. And you would put that all obviously on the account ledger, but you cannot charge interest on those $25 late fees. Okay. That's a good question. I'll take just a few more and then I have to run. Can an HOA file a lien on on a homeowner's home due to unpaid fines for roof or other violations? So the way the statute currently reads is that fines of less than $1,000 are not lienable, which means that if you've imposed a fine of $1,000 or more, provided you have the authority in your declaration to impose higher fines, and you have the ability or the authority in your declaration to lien for the fines, then you can. So you have to have authority in your declaration to adopt fines in excess of the statutory amount, which is currently capped at $1,000 per violation. And there has to be express language in your declaration saying that you can collect that fine as a lien. If you don't, then you can't. Okay. All right, let me take one more. Let's see. If you have to remove a board member and replace him or her, but can find no replacement, is that okay? Well, first, I want to clarify that the board cannot remove a director. The board cannot remove another board member. That is something that can only be done through a membership vote, through a recall process. If the director resigned voluntarily, and we're talking about, filling that vacancy, well, you know, you wanna have at least enough number of directors on the board to constitute a quorum. Whatever your quorum requirement is, depending on the size of the board, you want to have at least a quorum sitting on the board so that the association can conduct business. If you have anything less than a quorum, then you can't conduct business, right? And so that might be the case. If that's the case, then you'll definitely want to fill that vacancy. Okay, I think that's it. That's all the time I have for today.
Yeah, I know you have somebody in the waiting room, so thanks for taking the time out today to get the course done, Kirsten. We appreciate you. Have a wonderful rest of your day.
Thank you all. Thanks, Jeff.
Take care.
Bye-bye.
Bye bye.